Here are a few more tips you may want to keep in mind if you want to draft your own provisional patent application. Don't spend too much time discussing conventional details of structures that are well known in the prior art, unless you want to have the availability to use those details in claims down the road. The purpose of the written description in a patent application is basically to provide a word bank from which you can select words later to construct claims. You can amend claims anytime during examination, but you cannot amend the specification. You can only file a continuation in part or a subsequent patent application with a subsequent filing date. So it's important to have as many words as you can possibly find to describe your invention in the provisional patent application. And in terms of the balance of where you spend your words, it's important to try to focus them on the features in your invention that you think provide the clinical value. Think also about design arounds. You probably have a preferred embodiment based upon the thinking that's been done so far. But make sure you include embodiments that you have discarded unless they are frivolous and have no possibility of working. Oftentimes we'll see a patent on the preferred embodiment and inventors will surrender less preferred embodiments into the public domain, but a competitor may well be able to make those less preferred embodiments and become a competitive threat in the marketplace, even though you may have or believe you have clinical superiority. So you want to make sure you keep the option to block the competition from inferior but competitive alternative designs. Also, a good tip to keep in mind is focus strongly on the drawings. Think of the drawings as a storyboard or a PowerPoint slideshow that you're going to flip through as you're discussing and describing your invention to a knowledgeable an audience, but not an audience that has seen this invention before. If you think about it that way, there will naturally come to mind a sequence of drawings that you would want to show someone as you describe the invention. Normally there's an overall view, maybe a perspective view at an angle if there's three-dimensional aspects to it, maybe side elevational views. There's always going to be cross-sectional views if there's something going on inside that you can't discern from the outside. But the drawings are important and probably the place where you should spend the most time in your provisional patent application. The written description that accompanies the drawings is merely the narrative that walks through the drawings explaining what they're attempting to show. Also, claims sometimes appear in provisional patent applications. There's no requirement to have a claim in a provisional patent application. However, some people like to draft them, and it's really a matter of style. I think claims are helpful because if you draft a claim, it helps the writer focus on what are the key elements of the invention, and that in turn helps focus what aspects of the design you'll spend a lot of time discussing in the written description. Also, for more complicated reasons, claims can be helpful in European practice because the standards for written description law are different under European law than the United States law. And sometimes we have found that having claims in your provisional patent application increase the likelihood that you will be able to draft those claims later in your European counterpart after you file a patent cooperation treaty counterpart and succeed. Claims are also valuable because they guarantee that you will be able to demonstrate written description support as of the date you filed the claim. As everyone knows at this point, file as early as practical. The United States is now on a first-to-file system, which means that patent applications basically get time-stamped when they get filed. Whoever gets there first gets the patent.